In this lecture, we'll discuss about representation of the People's Act 1951. Basically, we would like to discuss the salient features of the Act. So, India is one of the largest democracy in the world. It is not only the largest democracy, but also the strong, stable, and vibrant democracy ever lasting since independence. And we found all in a democracy. Representation is the key and the fundamental factor. Even it an unitary or a federal constitution or a parliamentary form of government or a presidential form of government, wherever we go, we found election and representation is the key factor of a vibrant democracy, and in particularly India would be considered as one of the first countries after independence to implement and introduce adult franchise in the very form of universal adult franchise as provided under the Constitution of India from Article 324 to Article 329. So, India, after its independence, to hold the first ever general election to the House of Representatives or Lok Sabha and the Council of States or the Rajya Sabha, the two houses of Parliament, and to the legislative assemblies and legislative councils of different states. Indian Parliament enacted Representation of the People Act 1951. So, the very Articles 324 to 329 of the Constitution of India provides the very features of establishment of a constitutional commission, not a statutory commission, and that is the Election Commission of India for conducting election to all houses of the legislative assemblies and also to the both houses of Union Parliament, and also it conducts other various important elections such as the election of the president, vice president, and all other statutory bodies of the Constitution created by statute, and it also regulates the activities of political parties and to lay down qualifications and disqualifications, and it ensures a foolproof electoral process in India. So the representation of the People's Act 1951 is fundamental law that governs conduct of elections in India. It complements provisions of the Constitution, especially under Articles 324 to 329, which laid down the very legal framework for free and fair elections in India. So, the very objectives of the Act is to provide legal framework for conducting elections to both houses of Parliament and state legislatures, and to set qualifications and disqualifications for those candidates who enter into the field of election to both houses of parliament and to the legislative assemblies. Besides that, it also regulates political parties. Besides their registration and very conduct of political parties during elections, it further ensures transparency, fairness, and integrity in the electoral process. The Act has been amended several times to adapt to the changing political and social landscape, including incorporation of measures to curb electoral malpractices and improve democratic process in India. So, regarding the very conduct of elections as provided under Section 30 to Section 59 relating to establishment of Election Commission of India and regarding filing nomination papers and the very nomination process and the conducting election process. So the Election Commission's role as laid down under Article 324 of the Constitution and Section 29A of the Representation of the People's Act 1951, Election Commission of India holds authority to supervise, direct and control elections, including delimitation of constituencies, preparation of electoral rules, scheduling of elections in different parts of the country, nomination process. That is another important part of the function of the Election Commission of India as provided under the Representation of the People Act. People's Act 1951. Candidates must submit nomination papers within prescribed timelines. Returning officers scrutinize applications for eligibility and the very election process, which includes polling, counting of votes and declaration of results, and very use of electronic voting machines and voter verifiable paper audit trail has been integrated to ensure transparency. And further, it laid down qualifications for membership as per the provisions under Section 3 and Section 6. So, regarding House of People, Council of States and state legislatures, which are already laid down under the Constitution of India, further, under these sections from Section 3 to 6, it laid down membership qualifications for House of People, which is popularly known as Lok Sabha. A candidate must be an Indian citizen and must have minimum age 25 years and must be a registered voter in any parliamentary constituencies. And as regarding Council of States, which is popularly known as Rajya Sabha, a candidate must have minimum age 30 years, must be a citizen of India, must be an elector in parliamentary constituency, does not require residence in state from which contesting as after the 2003 amendment to the Representation of the People's Act 1951. And as regarding state legislatures, the members for state legislature have similar qualifications applying with the appropriate age requirements for both legislative assemblies and legislative councils. And now we would discuss regarding disqualification membership as provided under the Act under Section 8 to Section 10A. So, disqualification of members could be on conviction of any such criminal offences or for corrupt practices or on the ground of office of profit or for election expenditures. So, in regards to that, as provided under Section 8, subsection 1, anyone convicted for serious offences like terrorism, rape, corruption, dowry-related crimes, human trafficking, etc., leads to immediate disqualification for such membership. And Section 8, subsection 2 provides conviction for offences under laws like Prevention of Corruption Act, Narcotic Drugs Act, and as Section 8, subsection 3 of the Act provides disqualifications if sentenced to imprisonment for 2 years or more. And the very key point in regards to such that was decided by the apex court in a 2013 judgment in Lily Thomas versus Union of India. In particularly, it invalidated Section 8, subsection 4, ensuring immediate disqualification without waiting for appeal outcomes, and disqualification also on the ground for corrupt practices as provided under Section 9 of the Act. So, any member involvement in bribery, undue influence, both capturing or manipulation of voters, then such a member would be disqualified. So also disqualification for office of profit as provided under Section 10 of the Act, holding an office that offers monetary benefits under government authority, exception apply to certain designated offices only. Besides that, also a member can be disqualified for election expenditure violation limits as set by the Election Commission of India under Section 10A of the Representation of the People Act 1951. So, exactly, we would like to discuss the very reasons behind the disqualification, and as such disqualification on the very grounds of bribery, which automatically means offering money or gifts to influence voters. And when it is a corrupt practice falling under undue influence, it would be interfering directly or indirectly with free exercise of electoral rights. It can include threats, social ostracism, and religious spiritual manipulations, and when it falls under false information, providing misleading or false information about a candidate or their opponent, and also regarding promotion of hatred, it means creating enmity between different classes of citizens on the basis of religion, race, caste, community, or language. And this can be used to divide communities for electoral gains. And regarding undue influence, which is provided under Section 123, subsection 2 of the Act, it means interference with electoral rights. So any attempt to influence the electorate's free will through threats or manipulation, whether directly or through agents or it also includes coercing regarding caste, community, or religious identity. Besides that, convincing voters they will face divine or spiritual consequences for voting a certain way would also fall under undue influence. Besides that, false statements and corrupt practices. So, publication of false statements as provided under Section 123, Clause 4. Any intentional dissemination of false information regarding candidates' character or qualification to influence voters will fall under false statement. This extends scope of corrupt practices beyond just monetary or physical influence. So the very provisions regarding grounds for disqualification includes conviction for certain offences, involvement in corrupt practices, failure to declare election expenses, then interest in government contracts or works. Then we would discuss what exactly corrupt practices as it is defined under Section 123 of the Act. So, corrupt practices as provided under the Act, it includes bribery, undue influence, both capturing religious and caste appeals. And among that, we have already discussed relating to corrupt practices, and in particularly corrupt practices in relation to bribery, and as it falls under Section 123. That already we have discussed. And also undue influence appeals on religious caste and grounds, and also appeals on religious caste grounds, then both capturing it exactly means using political or pooling stations during the very election process by force or intimidation, and those electoral offences committed as under Section 125 to Section 136. So, in particularly as per the provisions of Section 125, which means promoting enmity based on religion, caste, language, etc., would be considered as promoting enmity, and it is an electoral offense as per Section 125. Then, regarding any kind of false statement as per Section 125A, it would be considered as an electoral offense, and it means misleading declarations regarding candidates' background. Then further, it would also categorize illegal hiring of vehicles as provided under Section 133 as considered as an electoral offense for transporting voters without proper declaration. So, these are falling under electoral offences as provided under Section 125 to 135 as promoting enmity, false statements, and illegal hiring of vehicles. And now we would like to discuss about the election expenses as provided under Section 77 and 78. So, as per the provisions of Section 77 and 78, it is provided under the Act that mandatory accounting candidate must maintain detailed records of all expenses incurred during the campaign, and the very spending limits as fixed by the Election Commission of India, which prescribes expenditure limits varying from state and constituency size as at now. The very limits for the House of People or Lok Sabha for a particular constituency is around 70 to 95 lakh rupees, and for assembly seats or constituencies it is within Rs 28 to 40 lakhs, and non-compliance or failure to submit or misreporting expenses can lead to disqualification as provided under Section 10 of the Act. And one of them is very important, that mandatory accounting, then the spending limits as set by the Election Commission, and for non-compliance of the direction of the Election Commission of India regarding electoral expenses, then it would lead to disqualification as per the provisions under Section 10A. And now we would like to discuss relating to election petitions as provided under Section 80 to Section 86. So filing of petitions in high courts initially, then it could be appeals to. Let to appeal to Supreme Court, so filing of petitions in regards to High Court. So petitions relating to all kinds of election issues could be filed in High Courts within 45 days of election result declaration. And the very grounds include corrupt practices, improper acceptance or rejection of nominations, and booth capturing. And as regarding the very appeals, all the decisions of the high courts can be appealed to the Supreme Court as per the provisions under Section 80 to Section 86 of the Representation of the People's Act 1951. And now we would like to discuss the regulation of political parties as provided under Section 29A, and in particularly registration of a political party with Election Commission of India. Then those conditions for recognition of a political party, then to show all financial transparency by that particular political party. So regulation of political parties as provided under Section 29A, it compels that all political parties must register with Election Commission of India under Section 29A, and the very conditions laid down under this section, that based on vote share, number of seats won, etc., are the criteria for recognition for a political party. Then all political parties must submit annual financial reports detailing donations and expenditure for the showing financial transparency. So these are the salient features that we have discussed in this portion, that is the part 1 of our lecture on Representation of the People's Act 1951. In our next upcoming lecture, we would like to discuss the various landmark judgments relating to the Representation of the People's Act 1951